the first to know. Nsem-Pii TV.
The Minister for Justice and Attorney General, the learned Godfred Yeboah-Dame, are granted an interview to Joy News. A fully packed interview. You also tie interview no Nsem-Pii. The learned Godfred Yeboah-Dame attacked about 4 different areas. Baako, the numerous judgment debt. Yeah, now buying, which is the new Patriotic Party, are buying etuia with regards to some dubious contract. The erstwhile Mahama administration since signed, yeah, immediately or different buying so. Emu be the 65% sale of toll to a private South African investor. Ebi the sale of the Tema port to French investor Vincent Balori. Ebi has to do with take or pay energy sector contracts. Ameri, any the Kaka Transfigura, just and a host of other contracts. And some of them will shock you. The amount of money or no Godfred Yeboah-Dame as an Attorney General, as save or mania, just say any assembly to us. Number 2, he talked about the numerous interventions with respect to infrastructural projects in the judicial sector. Houses for our noble justices of our court, the building of court across district, municipal and metropolitan assemblies, and also touching on that. Owiye and our bar and Nsem-Pii air course with respect to the Speaker, Alban Semana Kingsford Bagbin, says Supreme Court, Eddie Will Nyaba Bontin, was say, on fine Jumana de obey and obey. What are some of the implications and consequences? And also he touched on that. Obey and our casa at the far, the ambulance scandal. Ghana for the donor say a twa because after the ruling of the appeals court, the Leonard Godfred Yeboah-Dame ako Supreme Court. All seeking for some interpretations of the law and the annulment of ruling now Court of Appeal at the buyer. Now at discharging Dr. Casey Latterforsen and after Richard Japan. And also he gave an insight on that into a fully packed interview. And I'm able to so stay tuned and listen.
The point has been made that in a constitutional issue or a constitutional case, there isn't so much of a cause against a specific person. So there's no interest necessarily that a particular person in Ghana will have personally in a constitutional question. The question is for the court to determine the constitutionality of an action, a decision, or of a law. If Parliament passes a law and that is being questioned, it is not the interest of the members of Parliament at stake. Members of Parliament do not have a specific or direct or personal interest in a law at all. So the point has been made way back in 1980 with the famous case of Tufo Atenjera and other matters, and that was 44 years ago, that in a constitutional case, the community of interest or the community of interest of the parties is with the Constitution, not personally. So when the Attorney General is sued in a constitutional matter, it is not because the Attorney General has done X, Y, Z that the Attorney General has been taken to court. It is not because the President's personal matter is being dealt with by the Supreme Court at all. Because indeed, as I said, the Constitution is supposed to govern everybody, supposed to be the principle, the basic law of the country. And that is why the Constitution itself recognizes the seriousness of the instrument that it sets out for the people, and then determines a specific institution to interpret that Constitution. And the interpretation of that Constitution is binding on all. Again, it's also because a person has no direct or personal interest in a constitutional question. That is why the Constitution makes the Attorney General the defendant in all government actions. We all work on behalf of the government, but the government is not our personal property. The state is not our personal property. if I take a decision as a public officer, I take so by dint of the law that is imposed on me. And I walk away from this office, the next Attorney General will be saddled with responsibility for the action that we take. It tells you that we have no personal direct interest in it. So for that reason, I think philosophically, even Parliament is not supposed to be a party in constitutional actions.
So you think it was wrong for Parliament to have been made a party?
In my view, it's wrong. And I raised that point. The Supreme Court did not rule on it. But again, some other lawyer would have gone outside court and been making noise, writing articles in the media or the internet that the Supreme Court refused to rule on the questions. There's nothing at all. There's nothing personal. I raise my questions. If the court decides to rule, so be it. The courts do not rule unless it's very important to the exercise in question. I will not even pursue it. So the number of points I raised that day in court, that was one of them. That I do not think Parliament is even a proper party. The court did not rule. I also raised the issue that for me, the Council for the Speaker of Parliament cannot even be holding proceedings, holding our proceedings or holding everybody to ransom on account of failure to file processes, because indeed he is not even mandated, lawfully mandated by the laws of Ghana to represent the Speaker, because under the laws of Ghana, a public officer, when he is acting and seeks the services of any other person or institution, seeks the services of a person, will have to act so in accordance with the provisions of the Public Procurement Act, and that has not been done. The court did not rule again on that issue. I left it at that. I also raised the issue that even the Speaker's motion fundamentally was flawed, because it ought not to have been brought at all, because when the Supreme Court makes a decision and there's supposed to be a challenge to that decision, it must be in accordance with Article 183 of the Constitution. Article 183 of the Constitution requires that any decision or action, any decision, simple, any decision of the Supreme Court is subject to review. And the review must be conducted in accordance with Article 183, which is, it must be by a court of a minimum 7. The Speaker filed a motion not for a review, but to set aside the decision of the Supreme Court. That is even flawed fundamentally. It's unknown to the Constitution. The court did not rule on it. The court decided to look at it in merit and then dismiss it. That is fine. I don't have an issue with it. So I again will reiterate that yes, if I make any argument in the Supreme Court, just to answer your question again, if I make any argument in the Supreme Court siding with a case or opposing it, it is not because of a personal interest I have, but it is on account of a faithful view I take of the provisions of the Constitution. And it's quite clear, the Constitution is supreme, the sovereignty of the people is upheld by the Constitution, we are all subject to the Constitution. Parliament of Ghana can never be supreme, and indeed that supremacy of Parliament is definitely offensive to the Constitution and cannot be detained in the interest of a preservation of the constitutional order of the country.
The Speaker has had a press conference just today, and he's raised a number of issues. One of them is that he claims that the President and the Supreme Court have sinned against the Constitution. What's your take on that?
I think the first and foremost, we must recognize the irregularity or perhaps unusualness of the decision of the Speaker to make a press conference. In my short life, I've not seen a Speaker of Parliament address the nation on a decision of the court. That is because the Parliament itself recognizes the compartmentalization of rules set up by the Constitution. The Constitution has compartmentalized functions. The executive has its own functions to maintain law and order and to ensure that the needs of the people are satisfied in law. So indeed, it cannot be questioned how the executive decides to prioritize one project over another, unless it is in violation of the law. So certain things, perhaps, I think we must agree on it. Certain things have to be agreed, otherwise there cannot be a preservation of this democratic order of the nation. And that's my prime concern, that the road on which we're traveling if care is not taken, there will be disintegration of the democracy that we have chosen for ourselves. And there will be recourse to self-help, which ought not to be the case at all. I, with all respect, saw the speaker as trying a little bit too much. He's my very good friend, and for that matter, I mean, I'll just say so. Trying too much because, as I said, I did not see how conventional it is for a speaker to address the nation after a Supreme Court ruling and express his views on it. There's freedom of speech, no doubt. Every person has the right to express his freedom of speech on a decision of the court. President Joe Biden recently expressed his view on the Supreme Court judgment long Supreme Court decision, Roe and Wade, overturning the position of the court on abortion and what have you. Of course, we also want to tap into the Democratic Party now. Perhaps even the defeat was occasioned by such positions and all that it took after the Supreme Court had expressed a rejection of the position of the court taken in Roe and Wade, and of course, which of course leaned towards more of a conservative approach when it comes to abortion and all. So I think that it must be recognized in this country that we're all subject to the Constitution. And when this is done, we will require a certain level of humility, certain level of reasonableness, and a certain level of respect generally for other institutions.
You feel that the speaker is not exhibiting humility, reasonableness, and respect for institutions?
I'm not. You see, drive from as usual, right?
Sorry, I have to ask because you made the comment. I'm saying
because indeed, I mean, as I told you, I feel very convinced about certain matters I take to court. The recent case out of forcing, the Republic versus case out of forcing, I think that the matter clearly should be prosecuted and is prosecutable. All the elements of offenses had been proven. The trial was advancing. I was actually sitting in my study preparing to go and continue the trial when I received a phone call that the Court of Appeal had set aside the judgment of the ruling of the High Court on the submission of no case earlier on, made over a year before. Clearly, I was aggrieved, but in the area of good governance, I sit here, this office, I see numerous transactions that result in judgment, debt, and all that. And these are matters that were inherited. All the arbitration cases that we're conducting in this office, the numerous claims that we've successfully fought off, which of course I will be justified in thumping the chest of the office about, were matters generated in the NDC time. The various contracts that were signed without PPA approval, which resulted in litigation, the various contracts that were badly managed, which resulted in huge billions of claims, dollars and cedis against the government of Ghana, which were not for the diligent, if I may say, diligent hand of the Office of Attorney General in the NPP time, would have collapsed the Ghanaian economy. I mean, these are matters that the Ghanaian people ought to know about. In terms of good governance, you can again refer to the dubious judgment debts that were very much a frequency in the NDC time. The Royal Maids, the Asofotons, you name it. And there are more that I've seen in this office since I came. So indeed, I would think that in terms of the election of a leader's credibility, in terms of managing affairs of the state, in a way as to ensure accountability is very key. The leader's credibility in terms of managing the public purse in order not to occasion unnecessary losses to the state is very much fundamental, very, very key. And these are matters that have to be considered. I did not see that being a factor in America, or just the issues of economy. And as I said, issues of road construction, issues of free SHAs and all that are not factors in America. So our economy has different dynamics, and and we have to appreciate it.
You've made this point about the potential cost of arbitration, which through the work of your office has been avoided, and how it could have been a threat to the very existence of our economy if you hadn't won in these instances. There are those who point to this and suggest that we should then pay a bit more attention to the contracts that have been either signed or run under your government, and of course while you've been Attorney General, which could potentially put the next government, whoever wins, into serious debt. For example, in the energy sector, where we've currently racked up debts up to about $2 billion, simply because of how we have managed, or in some people's view, mismanaged the contracts we have with independent power producers. This has happened while you've been Attorney General. Has it been against your advice?
Well, I don't know how the debts were occasioned simply on account of the execution of some contract. I think the debts, of course, were occasioned principally by perhaps the failure to pay certain debts that accrue. So that's different from a situation where the government has signed a contract imposing burden on the people. And indeed, I think there was a complaint made in the early stages of the NPP administration, 2017, 2018, 2019, that there was excess supply, excess capacity generation and all that. And that is on account of the execution of many unnecessary power purchase agreements. That's a matter for the technical people at the Ministry of Energy to really look into and determine. But there was such a complaint. I believe that the media actually gave a lot of publicity to it and all that. So if indeed there's the execution of so many unnecessary agreements in the NDC time and all that, clearly it imposes liability. And I remember that one such agreement, which was terminated, was what led to the famous 170 or 160 million judgment debt in the name of a GPGC, the traffic bureau one. That was it. That was just before I assumed office as Attorney General. So clearly, I mean, as I say, that when it comes to the execution of contracts and all that, we must pay particular attention to it. And indeed, when there's a complaint that the government is unnecessarily signing contracts, it is one that cannot be taken for granted. We must look into it seriously. I thought that there was a legitimate basis for a scrutiny of all those complaints by the MPP during that time. Of course, some people played political football with it and tried to justify the execution of those agreements and all. And we have seen the consequence of it.
We must, however, point out that a lot of these contracts that your party complained about, that they were unnecessarily signed by the previous government, were renewed when the time came. So it would appear that you...
No, I'm not aware of any such. I mean, as I said, there's also what we call division of labor in government. It's a point that must be recognized. There's division of labor in government. The Attorney General's remit in the Constitution, of course, is to be principal legal advisor to the government on all issues. But the Attorney General only acts when certain matters are being brought to their attention. And of course, with all respect, I'm a lawyer, and on behalf of the state, speaking on such an important issue, I would not speculate at all. You have not referred to a particular contract that you see that this contract was signed after referral to that Attorney General.
I'm talking about the independent power producer contracts.
I'm not aware of any such renegotiation that was done pursuant to the advice of the Attorney General. So really, in all honesty, I'm unable to speak to it. Because I think it will be quite helpful if there is a particular instance of the execution of such a contract alluded to and pointed out. Many a time, when agreements come which are unnecessary and all that, we advise against it. So I'm not in a position to actually speak
is this to say that you have not been, your advice has not been sought on any of the...
I'm saying that you have not alluded to a particular advice. You're just making general statements, with all respect. And those general statements, I'm not able to respond to them because I'm not, with all respect, speaking like a communicator on radio who is at liberty to make comments on matters and perhaps be excused. because the person has no evidence. This is the Attorney General of Ghana. And I think it would be very fair for me to say that if I have to comment on an issue, it must be in relation to a specific issue. Then you must clearly point out which specific contract and that kind of thing. And I'm saying that you have not really done that, and I'm unable to therefore respond.
Okay, we will come back to this if time permits. But let's recently, when you spoke at the inauguration of the first ever conference for public sector lawyers, you made this point about arbitration, and you enumerated a number of cases which you've had to defend the government of Ghana on, and as a result of your success, we have avoided some trillions of dollars worth of debt.
Right.
The suggestion here is that, well, I mean, you're Attorney General, that's your job. You know, you've done your job. We ought not to be saddled with debts if we have a competent Attorney General who can protect us from it. Surely that's where it ends, is it not?
Yes, that's where it ends, and what was not really an attempt to lament or perhaps draw attention to myself for success and all that. It was actually an attempt to draw attention to the potential pitfalls the nation will run into in the event of a default on some of the most important matters that ought to engage our attention. And the conference, of course, was the first of its kind, organized by myself, had never been done by this office. I found it very necessary to organize such a conference because, drawing from experiences that we had had